partners on this great event here today. And welcome to all of you. We're really to have such a great crowd. My name is Kip Hale. I am the Senior Counsel of the ABA Center for Human Rights, and I'm the Director of the ABA's International Criminal Court Project. And let me first start with what may be the most important information of the day that you'll learn, and that is the Wi-Fi code and the Wi-Fi network. That way you can tweet out all the important things that our panelists are going to be saying. With your indulgence, let me give you a brief introduction to the ABA, the Center for Human Rights, and the ICC project. As some of you are familiar with the American Bar Association, and get ready for lots of qualifiers. We're the world's largest organization, voluntary organization of professionals, with nearly 400,000 members. And the ABA Center for Human Rights, based here in Washington, D.C., as the name connotates, is the focal point of our over 3,500 entities within the ABA, are focal points on domestic and international law. The Center for Human Rights has various programs on human rights offenders, called the Justice Offenders Program, business and human rights, atrocity prevention, anti-trafficking, and of course the International Criminal Court Project, which is one of the organizers of this event. The project is essentially the fulfillment of ABA policy stemming all the way back to 1978, where our House of Delegates voted in 1978 that a permanent international criminal court should be formed. We have policy to urging the U.S. government to join the International Criminal Court, and short of in session, or not ratification, I should say, helping support the casework at the ICC more robustly. So as I said, the ICC project is a fulfillment of those policies, and in short, we do so through advocacy, education, and practical legal assistance. We have a very distinguished board of advisors. We are pleased that Judge Patricia Wald, who is our moderator today, is on that board of advisors. And I encourage you here's our website, aba-icc.org. And I encourage you to check out our website. We have great interactive educational material about the ICC and about U.S. ICC relations. And please, when you're done following and liking our partner groups, please do so of ours as well. And lastly, I'll say that we also run International Criminal Justice Today, a magazine with Stanford Law that does polling, news, opinion on international criminal justice matters. Now, why we're happy to be hosting this event is essentially because the ABA has done some great work as it relates to Syria and the region. The ABA president, starting in November of 2011, urged the UN Security Council to refer the matter to the ICC, and it has done successive presidential statements from there, which, is anyone familiar with the ABA, is incredibly rare to get the ABA president to do something like that. And additionally, in this very room, we did a experts roundtable meeting on atrocity accountability in Syria about 2 weeks ago. And let me just finally end on one small note. The importance of international criminal justice and atrocity accountability is when it's done evenly and impartially without fear or favor, not just against our political opponents. And so it's really important. I'm sure our panelists will flesh that out in more detail. But the benefits as we see peace and security do not occur if international criminal justice isn't done evenly and impartially. Now with that, I will introduce our moderator and allow her to introduce our panelists. Judge Patricia Wald was the Chief Judge for the U.S. Court of Appeals for the District of Columbia from 1979 to 1999. And she was, after that, from 1999 to 2002, she was a former judge at the International Criminal Tribunal for the former Yugoslavia. Now, I would waste all of your time by going through all the awards and honors that she's received, so I'll just give a truncated one. On November 20th, 2013, she was awarded the Presidential Medal of Freedom, the nation's highest civilian honor, and was recognized by the Constitution Project as a 2011 Constitution Champion. And finally, in 2008, she was a recipient of the American Bar Association's highest honor, the ABA Medal, and was a recipient of the Margaret Brent Award of the National Association of Women Judges. And please join me with welcoming Judge Wald.
Thank you, Kip. Good afternoon and welcome to our panel discussion on current accountability options for crimes under international law committed in Syria. Now, the impetus for this panel is a just issued collaborative report by SJAC, that's the Syria Justice and Accountability Center and the Ceasefire Centre for Civilian Rights. The report examines the most frequently discussed options for a justice mechanism to deal with war crimes and crimes against humanity committed by the several groups involved in the conflict in Syria. It does so from the point not only of international justice, but that of the Syrian victims and communities who are impacted by the war crimes, combining legal and practical considerations. Now, the format we're going to follow is, after I introduce the three discussants here at the table, is that they will each give a 10-minute presentation on their view of which of the options are feasible and or desirable and when they might best be invoked. I will then try to advance the discussion by asking several follow-up questions to allow them to elaborate and cross-exchange their views. After that, you, the audience, can ask questions which will be channeled through one of the staff, people who will circulate among the audience and pick up the questions, give you a microphone. Thank you to the ABA, International Criminal Court Project, on which, as Kip said, I serve as a member of the Board of Advisors hosting this event. And now, without further ado, for the panelists. My introductions of them will be brief, despite their very impressive credentials. The first person that we're going to hear about is, I believe, the principal author of the report, one of the principal authors. Okay. That is Mark Latimer. He's the Executive Director of Ceasefire Centre of Civilian Rights. He worked on the Pinochet case when he was Communications Director at Amnesty International UK. He served for over 10 years as Executive Director of Minority Rights Group International, where he worked on some of the first Congolese cases before the ICC. Mark Latimer has led a number of international human rights missions to Iraq and to the Democratic Republic of Congo. He's the author or editor of many books, including Genocide and Human Rights, Justice for Crimes Against Humanity, and I'm sure many others. Now, Mark is going to start us off by reviewing the available justice and accountability options for crimes committed in Syria under international law. He's also going to review the feasibility of each option, the ICC, hybrid courts, extraterritorial jurisdiction of domestic courts, and he's going to outline ways that abuses might be prosecuted and the feasibility or desirability thereof. Mark?
Well, thank you very much, Judge Wolf. I'm very pleased to be here with such a great audience. I am just one of the authors of this report. The other two are in fact with us, Shabnan Moshtahedi and Lee Anataka, who are there at the back. And I'm sure they'll be able to answer some of the more difficult questions that are put later on. Last December, I was teaching on a training program on international human rights and humanitarian law standards for Syrian judges. We had about 30 judges and senior lawyers working for the court system, all from Al Jazeera in northern Syria. We were having a certain point of discussion about rights in detention, and one of the judges was talking about their experience of having people brought before them who he suspected of being mistreated. But then he said, well, you should ask our colleague who knows all about it. And everyone in the room turned round and looked to one of the judges who hadn't said that much. I'd spoken with him the night before. He was, I guess, in his late 50s. He was a very reserved, a very sort of dignified presence. And he hesitated a moment, and then he said, well, all right, I'll tell you. I was imprisoned, and I was held, not in a cell, but in a toilet, in a restaurant. And after a few weeks, I was brought before a judge. And we went to the court, and afterwards, they they put me back in the toilet. And he was imprisoned for 2 years. And then he said, and then they let me go. They let me go. And it was just as arbitrary a decision as when they first imprisoned me. So he said, so I know why standards in detention are so important, but I also know why it's so important not to have arbitrary decisions. Now, I thought I'd start off by relating that to you, because it speaks both to the depth of the problems in Syria, but also to the fact that there are many people in Syria today who not only are hoping for a better justice system and for some justice for what they may have suffered in the past, but are also prepared to work hard for it and to work for it in, believe it or not, an impartial way. This report that we've produced this week is intended to be a contribution to those efforts, and in particular look at what the international community can contribute to that fight. Many people say to me nowadays, oh, but there's nothing left. What can you do? It's a complete mess. But I always think about what I've learned from some of the Syrians who I know, including on this panel, but many of the Syrians that I've worked with who are working for better justice. And the lesson is partly not that we can achieve everything immediately, but there are small things that can be achieved now in the hope that maybe greater things will be achieved in the future. So I want to review very briefly the 4 main options for accountability that we have discussed in this report. The way I think we're going to do this is that I'll outline the options, and then when Mohammed gets to speak, he'll tell you why most of them are not a very good idea at all. But I think it's worth thinking about what can potentially work, but bearing in mind not just that there are some things that could just about work now, but to think very clearly about what sort of effect they might have on future justice prospects. And it's that, I think, rather difficult judgment which we believe to be one of the strengths of the report and the work we've been able to do. So what are these options? Well, about a year ago now, the UN Security Council vetoed, there were two vetoes of a draft resolution to refer the situation in Syria to the International Criminal Court, as I'm sure you all know. And I think at that juncture, everyone assumed, and you often certainly hear it written about in the media, that the ICC option was for all intents and purposes closed. That's not quite correct. Certainly, as Syria is not a state party to the Rome Statute of the ICC, and as the Security Council is not going to refer the situation, the options are limited. But you have to remember that the jurisdiction of the ICC does not just extend to the territory of state parties, but also to the nationals of state parties. And one of the features of the Syrian conflict, particularly in the last 2 years, has been the enormous involvement of fighters from foreign nationalities in Syria, including many who come from states parties to the Rome Statute. Now, there have been some high-profile examples of European nationals fighting in Syria, but also there are many thousands of nationals, particularly from Tunisia and from Jordan, both of whom are states parties to the Rome Statute. So the prospect of there being some form of ICC jurisdiction is perhaps becoming more possible. For me, this is partly bound up with the question of Iraq's potential accession to the Rome Statute of the ICC. The fact that most of the senior commanders, in fact basically all but one of the senior commanders of ISIS, of the Islamic State in Iraq and Al-Sham, are actually Iraqis. If Iraq was to accede to the statute, that would present for the first time the potential ability of the ICC to have a jurisdiction over some individuals who were responsible for very serious atrocities in Syria. But Iraq's accession to the ICC is still unlikely, and maybe we can have a debate about what is possible. So that's the ICC. The next potential option are a range of other international tribunals under different models. If the Security Council is not going to refer Syria to the ICC, nor is it going to vote to establish the sort of ad hoc tribunal that we saw, for example, for the former Yugoslavia, on which our distinguished moderator was a judge. So that option's closed. But there are a growing number of what are generally referred to as mixed law tribunals or hybrid tribunals now in operation for various country situations. Now these combine mixture of national criminal law and international standards and mechanisms, and usually have in the past been a combination of, or they have been established under an agreement between the state concerned and sometimes the General Assembly, sometimes a vote of the Security Council of the United Nations. The difficulty here, of course, is that Syria would hardly want to play ball. There was a lot of discussion last year here in Washington about the possibility of one of Syria's neighbouring states establishing the tribunal, potentially on the basis of an agreement with the UN General Assembly, and effectively extending its own criminal jurisdiction over the situation in Syria. Once again, this is another option which I think is potentially unlikely, but we could discuss it. Yesterday, when we were doing a briefing for UN, different delegations to the UN, the representative from Turkey said, "This is very interesting, but I can assure you we have absolutely no intention whatsoever of establishing a tribunal which would have jurisdiction over Syria." So I think that was an important reality check to that option. Much more likely is the prospect of some form of foreign national jurisdictions prosecuting those who are responsible for grave crimes under international law in Syria. Now, in the very kind introduction, Judge Ward mentioned that I was partly involved in the Pinochet case when the former president of Chile was arrested in London pursuant to an extradition warrant. In fact, there were a total of 4 European countries who sought his extradition during the course of the Pinochet trial, and we were also pursuing the potential for a prosecution of him in the United Kingdom as well. This was on the basis of the extraterritorial jurisdiction established under the UN Convention Against Torture. Now, Syria is a party to the UN Convention Against Torture, and the same extraterritorial jurisdiction established under that treaty could potentially be used to try Syrians who were responsible for torture in Syria. The UN Convention Against Torture is not the only such treaty. There are a growing number of treaties now which establish extraterritorial jurisdiction. Quite apart from a broader discussion which we might have on the question of universal jurisdiction, or whether there are courts which would wish to assert a universal jurisdiction based on the gravity of the crimes, the fact they often constitute war crimes or crimes against humanity that have been committed in Syria. And finally, we talk about the potential of civil actions for civil damages also in foreign national courts. Now, I think there are a number of obstacles to that, growing number of obstacles, particularly in European courts, because of some recent decisions basically strengthening the rule of state immunity from prosecution. But such actions may be possible, both in Europe and also, of course, here in the United States, for example, under the Torture Victim Protection Act. So those were the main options that we have discussed and outlined. I look forward to sort of discussing what is possible and also what might be constructive in the current context. But I will just end by saying this. Foreign national prosecutions, particularly in European courts, are not only a possibility, they are starting to happen. And we are going to see a growing number of them certainly right across Western Europe. But these are almost exclusively prosecutions of individuals who are commonly referred to as foreign fighters, those who go to fight in Syria. They're often being prosecuted under anti-terrorism legislation, and they are often prosecuted because of the perceived danger such individuals present to the security of the states to which they may return, i.e. European states. I think the extent to which we are concerned as an international community with the perpetration of grave crimes in Syria has almost entirely, and in the course of less than a year, been overtaken by concerns about the security of Europe and also the security of other Western countries in terms of what's sometimes referred to as blowback from foreign fighters who go to fight in Syria. Not only does that get the relative scale of the problem terribly wrong, it also means that we are seeing the growing use of foreign national prosecutions almost entirely to prosecute one side, a very particular part of one side in the conflict. And what is more, they generally speaking, and believe you me, I've spent a lot of time over the last year enumerating and documenting the terrible crimes committed by groups such as ISIS, but at the same time, these are not the gravest of the atrocities that have been committed in Syria. And certainly, if you look at the scale of what has been done in Syria and the tens of thousands of civilians who've been killed, for us to conduct foreign national prosecutions only of foreign fighters seems to me to ignore those with greatest responsibility for the atrocities, and that must surely include senior members of the Syrian government. And I think I'll stop there.
Thank you. Okay, our next speaker is going to be Mohammed Al-Abdullah. Have I got that right?
Yes, you did.
He's the executive director of the Syria Justice and Accountability Center, a democracy researcher and human rights activist. He received a Bachelor of Law from the Lebanese University in 2007 and a Master of Public Policy from George Mason University here in the DC area in 2014. He worked as a research assistant for Human Rights Watch in Beirut, from whence he covered the Syrian beat. Al-Abdullah is a former political prisoner who was himself imprisoned in Syria on 2 separate occasions for his work defending human rights and lobbying for political reform. Now, he is going to review the Syrian perspective on each of those justice options that Mr. Latimer described, and the potential impacts of those options upon Syrians, both in terms of their opinions toward the conflict as well as their physical security. In particular, he will discuss why certain incomes could leave some Syrians dissatisfied and why some Syrians could have some misgivings about the impartiality of international prosecution. That's a very provocative mandate. So
Thank you very much as well, and I want to thank ABA again, once again, for hosting us here and providing us with this spot. And I want to go back to Mark's comment. Yeah, nothing will work in Syria. The situation is really bad, and that's not really the spirit of what I'm trying to say here, but more. I want to communicate to everybody, including our colleagues in the international community, diplomats and missions, and definitely on the U.S. government side, that no matter what jurisdiction we try to use for Syria and for accountability phases of Syria currently, there's lots of consequences that might be positive or negative, impacting the long-run Syria in the future. And if we don't take those in consideration, we might be basically jeopardizing the future of Syria and unfortunately repeating some of the mistakes we've done before in Iraq, in Lebanon, and elsewhere in the world. And basically, some of these, and we had this conversation earlier today, some of these comments might sound like negative things, like this is not happening, this will not happen, but it's more, could be interpreted as risk we're flagging now to basically put it in everybody's agenda. We have to watch for these things, and we have to be careful not to repeat these mistakes and turn those into recommendations rather than basically points of cons for the jurisdiction. So I won't go really in details for the jurisdiction, but I want to highlight a couple of the ideas came in the report and Mark has touched on. Basically, the ICC jurisdiction, we understand the veto happened, but having jurisdiction over the conflict in Syria through the foreign fighters and their nationality and their nationals of several states, that state members to the Rome Statute, will undermine the principle of the ICC targeting the most responsible perpetrators in armed conflict or in violations. And this is not only limited in intervention and involvement of the ICC in the cause, but also basically targeting low-level perpetrators from the foreign fighters who might be nationals of these countries and leaving people like Assad and his inner circle out of the jurisdiction. Of course, that's for pure legal reasons and jurisdictions reasons. However, in the Syrians' heads and minds, it's not being interpreted this way. It's being interpreted, you're targeting one side of the conflict, and you don't care about us, you don't care about what Assad is doing, as long as it's not foreign fighters or jihadis. Of course, the Office of the Prosecutor of the ICC rejected such jurisdiction. It was consulted in that, and they rejected to involve in the Syrian conflict on the foreign fighters' jurisdiction. The other aspect of the ICC as well is ICC will has very limited number of cases, 3, 4, maximum 5 cases to be reviewed from the Syrian conflict. And here where we have to look constantly about the domestic prosecution inside Syria. That requires lots of capacity building in Syria, requires lots of preparation for the country, and requires lots of work in the grassroots for the people to accept the idea of justice and transitional justice as well. Quickly on the hybrid tribunal might sound more positive option at some point, because from one angle it will be accepting more number of cases. ICTY, if I'm not wrong, took 116 defendants at some point, and that's not something the ICC will be able to do at any level. However, the hybrid tribunals more likely to be politicized and less impartial, and those concerns are there and exist in the minds of Syrians and the minds of the countries around Syria, who Turkey clearly said we're not interested in hosting such tribunal, but hosting a tribunal outside. Of course, the tribunal either will try in absentia some of the defendants, or will have access to the people who leave the country, and the people who left the country currently are the anti-Assad camp. And again, we're back to the one-sided issue. There were a debate last year here in DC and elsewhere about special tribunal for Syria or hybrid tribunal for Syria. And in the report we came to the conclusion this might be a positive step in the post-conflict era, when the conflict has concluded and Syrians will be able to host their own tribunal if the security situation permits. I go to the third jurisdiction quickly, the foreign national jurisdiction, which is the most usable one or feasible one at the moment. Sweden recently has put a former Free Syrian Army fighter in prison for 5 years. The guy posted on Facebook a video for himself torturing someone in Syria, and he was arrested. He faced prosecution, and he ended up in 5 years prison term. And these cases are indeed growing now in Europe because there's a huge number of Syrians basically leaving to Europe, either seeking asylum or getting a boat and crossing the Mediterranean and ending up in Europe. And B, there's a high concern and security, national security concern from the European governments. Those are jihadis and foreign fighters, and extremists might be doing some terrible acts in the European lands. However, as Mark mentioned, there's a problem in the perception here that these courts for national prosecution are targeting one group and one side of the conflict, and that's not bringing really good perception of Syrians, and it's not showing there's meaningful justice in court being prepared for Syria. The main concern Syrians might have is some of these cases might sound like the justice that the Europeans try to present or the international community try to present. It's not the case, we understand, but there's a risk and concern among Syrians that we don't have access to Assad, we don't have international criminal court, so that's the minimum we can do, and that's the justice for Syria. That's the accountability efforts we're going to put together. We're going to capture a couple of people here and there, put them in trials for anti-terrorism laws or for migration violations sometimes, and we end up with, that's a justice case for Syria. And the problem here is, besides targeting low-level perpetrators, because the high-ranking people will not really get in a boat and escape to Europe. The problem is not full justice. It's not meaningful justice. For Syrians, if they don't see somebody from the government side in a justice, they're not accepting this as real justice and meaningful justice. And the risk here is Syrians will not accept this. They will consider you're tricking us, and they will fight back. And they might kill people back. And we end up in a cycle of revenge and killing back because there's no meaningful justice processes in place. And the civil actions is one of the interesting cases could be, or jurisdiction could be invoked. However, it brings as well some of the limitations here because you need to find the perpetrator in a country and you find the victim there at some point to file a civil action case or plea. The problem is that the high senior people from the Syrian government are very corrupted and they have tons of money and simply they will pay people money and compensation. And that's not solving justice again. We're basically finding a mechanism for preparation for only individuals and small number of cases and limited scale. Besides all these limitations, we might run in a group of practical and ethical challenges overall, regardless what is the jurisdiction we might touch on. And quickly I'll go through a couple of points. Currently we don't have access to Syria, and our access as documentation group is becoming very limited and very difficult, let alone a prosecutor to get access to physical documents, interview witnesses, forensic evidence, etc. And here there's security issue, of course, and the access itself is very limited. There's the impartiality question, which is coming a lot from lots of people. If we establish a tribunal currently for Syria or start any mechanism of accountability during an active conflict, how impartial this mechanism would be and how fair this trial would be. And of course, the consequences of this, you can look simply in Iraq and see what Iraq tribunal, Saddam Hussein tribunal, and how Iraq is doing today. The Sunnis feel that the tribunal targeted them, the Shia minorities or majority in Iraq used that as a point of revenge against Saddam Hussein. That did not really brought stability to Iraq in the long run. And if you look at the other examples like Lebanon, where basically an amnesty given to everybody committed a crime during the civil war, and there's no justice. Still, there's 100,000 disappeared people, and there's a huge problem in accountability. Therefore, Lebanon is not really a stable country, a stable nation. I will conclude here is I'm not really pessimistic, I'm realistic a little bit. I understand this is very difficult and challenging problem here, especially when the conflict goes on. And before we have a conclusion of the conflict, these options and jurisdiction might not really be feasible or accessible. The big caveat and concern here is establishing a justice mechanism that will fail, will not deliver justice to Syrians, or will not deliver meaningful justice that Syrians accept as real accountability and justice. Here, I think we're risking throwing the country a disaster. Basically, people not accepting a court, rejecting a court, attacking the court if the court inside Syria security problem would be. And we think, as a conclusion for the report, we think really postponing the justice and accountability processes till the conflict and or to a later stage where it's more feasible and more accessible and more high rate of success potentially exists. It's much better than having a justice mechanism that might lead the country to further fragmentation and polarization. I'll stop here and happy to discuss more.
Thank you. Our last speaker is going to be Jennifer Trahan, who's an associate clinical professor at the Center for Global Justice in New York University School of Continuing and Professional Studies. She's consulted for the UN Special Court for Sierra Leone and and the International Center for Transitional Justice. She's also the author of Genocide, War Crimes and Crimes Against Humanity, member of the Human Rights Committee, the Association of the Bar of the City of New York, and of the American Bar Association's Task Force on the International Criminal Court. And she is going to report to us on prior applications of transitional justice in conflict zones, such as in the former Yugoslavia and Rwanda, and the lessons we might learn from these past transitional justice processes, highlighting considerations and challenges for extraterritorial legal action, about which we've heard previously.
Thank you, Judge Wald, and thank you, Mohammed, for inviting me to be here today. It's a pleasure to be on this panel and try to contribute to the difficult issue about accountability for crimes in Syria. So I was asked to frame some lessons learned from the field of international justice. So I've thought of 9 of them. And in going over these, maybe I can weave in a little bit some response to Mark and Mohammed's thoughts on this. Probably this audience doesn't need convincing of my first point, the importance of prosecuting all sides in a conflict, and we've already heard this, and we can draw this from a number of tribunals. I'm just going to list my points, then I'll go through each in turn. From universal jurisdiction cases, I was going to mention Spain setting off processes in Chile, Argentina, Guatemala. We might look at the Pinochet case as well. And my lesson is you have to start accountability somewhere, and it may not be your perfect mechanism, but it's important to get going. Third, and this conflicts slightly with what Mohammed just said, and I would draw my lessons from Afghanistan, you do not wait for peace to be fully achieved before you set off on accountability. Fourth, I'll draw from the Iraqi High Tribunal lessons we need to learn, the missteps of the Iraqi High Tribunal, about the importance of fair trials and the corollary appearance of fairness. Fifth, from the negotiations of the ECCC, Extraordinary Chambers of the Courts in Cambodia, I thought of the lesson, the perfect is the enemy of the good. If we wait for a perfect tribunal, it may never happen, and imperfect justice may be better than no justice, but I think we have to qualify that. 6, I was drawing from the situations in Yugoslavia and Rwanda. We may need multiple tiers of justice. We see this in those situations. 7th, from the ICC prosecutor's trips to Kenya and Guinea in 2013, where she projected that the court was watching. I think we need to learn the importance of projecting that accountability is coming. 8th, justice must not be bargained away at the negotiating table. And 9th, and this is a direct response to the report, and maybe a little of what I find Mohammed's pessimism, I think we need optimism to stay the course for the best possible justice outcome. All these attempts to create tribunals are really difficult accomplishments, but we need to have some optimism for achieving it. So I know it's a lot, but so maybe the first one, I don't need to elaborate much on the importance of prosecuting all sides. Probably everyone in the room gets this. And some of our tribunals have done this and have not. Of course, others have not. Our field starts with the Nuremberg Tribunal, which of course did not. Our contemporaneous tribunals have done better on this, not all of them. But for instance, Sierra Leone Special Court prosecuted all 3 key warring factions in the Sierra Leone Civil War. The ICTY prosecuted those from all sides. So they do well on this. So yes, absolutely, if there ever is a freestanding tribunal, whether it's an ad hoc or hybrid, a special Syrian court, an Iraqi tribunal, you would never want a tribunal that has jurisdiction over ISIS crimes or Assad regime crimes. It would have to have jurisdiction over a situation or crimes in a certain territory, and the ICC ideally would have jurisdiction over an entire situation and not just the foreign fighters. But in terms of what is possible today, we heard the ICC cannot prosecute until, if there is someday a Security Council referral or Iraqi accession, or certainly not Syrian accession under the current situation. But, so at the moment, the International Criminal Court cannot do a fulsome look and could only prosecute foreign party nationals from Rome Statute state parties. But someday, hopefully, we will have a more fulsome justice endeavor that would prosecute on all sides. My second point was prosecuting somewhere. I recognize our current possibilities are very limited, but I think it's important for these cases to proceed and to project that these cases are proceeding, because otherwise you have really no hope of creating deterrence. And in terms of the International Criminal Court, I differ a little bit with the SJAC findings, which say, the court really won't go ahead unless we have high-ranking individuals implicated. I think the gravity threshold of the International Criminal Court, which is fairly high, would also be triggered if there were foreign fighters implicated in extreme mass atrocity situations. And we have an estimated 20,000 Europeans fighting in the region, over 2,000 Tunisians, 1,500 Jordanians. These are Rome Statute state parties. I think it's quite likely they will be implicated in mass atrocity crimes. And I think in those kinds of situations, the court should proceed. It would be a powerful place to start. As mentioned, European countries can do isolated prosecutions, individuals returning to the countries. The corollary, of course, is also preventative prosecutions, trying to prevent individuals from joining in ISIS. A number of anti-terrorism statutes can be used in the U.S. The U.S. is doing these prosecutions. They're occurring in European countries as well. So these are current mechanisms that can be used. I would draw the lesson from the situation in Afghanistan. You don't wait for peace to be achieved before starting accountability. So in the early years of the Karzai administration, the UN was very much convinced that we need peace first, and someday there will be accountability. And in Afghanistan, of course, we have neither peace nor accountability. And whenever initiatives related to accountability seized some momentum in Afghanistan, such as the Afghan Human Rights Commission, an ambitious mapping project, they were thwarted. And of course, now there is a domestic amnesty. So I think it's much more accepted that accountability and peace need to be pursued simultaneously. Also, we don't want to wait for accountability, because if you wait till all the crimes are done, you are creating no deterrence. So the only possibility of deterrence working is if you set off on prosecutions midway through. Then you might ask, well, are individuals who join ISIS, are they going to be deterred? If Assad regime members are already heavily implicated in atrocity crimes, are they going to be deterred from other crimes? I don't know the answers to these questions, but I can only say...
I know, I can help you out.
No. You have to wait.
I'll give you an opportunity.
I want to say that we can only use the tools that we have at our disposal and attempt to do this. We don't know to the extent, it goes back to our discussion, would Pol Pot ever have been deterred? Are these rational actors? But we can only use the tools that we have and attempt it. So fourth, I think we can learn a lot of lessons from the Iraqi High Tribunal and its missteps. And I think these are very important to analyze, because it might be our closest corollary example, and we don't want to go down this path. The Iraqi High Tribunal was a national court tribunal set up in Iraq to deal with Saddam Hussein era crimes. The first case was Dujil, a relatively small crime scene. Saddam was executed after the verdict there. The second case was the Anfal, the 1988 genocide against the Kurds. And there were further trials after these. While the tribunal, I think, did make some accomplishments and achieve some level of justice, there were tremendous shortcomings in due process, and the appeals were wholly political without any reasoning. The appearance of fairness, which is the corollary, we need fair trials and the appearance of fair trials, was undermined at a number of different stages in Iraq by intemperate remarks by government officials, by withdrawal of judges from sitting on cases, yanking them off the panel, replacing them with more friendly judges, and in the way that executions were conducted and reported. I think the Iraqi High Tribunal's work took an initial downturn early on when they incorporated the death penalty into the statute. And when it became clear the Iraqi High Tribunal would have the death penalty, we see European forensic teams withdraw. ICTY judges who had been slated to do training were pulled out.
Some of us went.
You went, but in a personal capacity, right? Not as the ICTY.
I'm not sure the Iraqi judges knew I was in a personal capacity.
The UN buy-in was lost, completely lost because of the death penalty. And that meant the Iraqi High Tribunal was only assisted by the US in the form of the Regime Crimes Liaison Office and one Canadian national on the defense teams. And this isn't the kind of internationalized assistance we would like to see. I think it leaves open the optics for that the US was in a position to control this tribunal. I don't think they did. If anything, I think the RCLO at times was marginalized. So I'm not accusing the US of this, but it's not the kind of internationalization one would like to see. And I think we need to have this discussion because I do think that there's a strong chance Syrian voices will want to have the death penalty. It exists in Syria. There was a strong push for this in Iraq. And I think it's a concern because you're going to lose all UN backing, all European backing, for any kind of ad hoc or hybrid tribunal. And it's the path that was taken in Iraq, and it needs not to be followed. I know I'm going on a little long. I'll try to wind up more quickly. From the ECCC negotiations, this is the Extraordinary Chambers of the Courts of Cambodia. I would say the perfect is the enemy of the good. In negotiating that statute, it was always there were concerns that the tribunal would be open to manipulation. And there were times when it was thought, well, maybe we shouldn't have a tribunal. We can't guarantee its independence. Well, they continued the negotiations. They tried to put in as many protections as possible with the supermajority voting formula. And ultimately, there is this tribunal. But yet, the fears did come to pass. There have been attempts to manipulate the tribunal's work and derail cases 3 and 4. So these fears did come to pass. It is a somewhat flawed tribunal, but it is the only possible justice for the 2 million victims of Khmer Rouge crimes. So had we waited for perfect justice, we would have had none in Cambodia. From the Yugoslav and Rwanda tribunal experiences or crimes in the region, I think we learned that there may need to be a multi-tiered solution in any situation of mass atrocity crimes. So at the Yugoslav tribunal, they tried primarily the highest level perpetrators. We have a hybrid in Bosnia, the state court. So it used to have international and domestic judges. Now it's reverted to domestic. And then you have local cantonal courts in Bosnia. In Croatia and Serbia as well, you have specialized war crimes chambers. So it's a multi-tiered approach. Rwanda as well, you have the high-level perpetrators tried at the Rwanda tribunal. You have Rwandan domestic courts, and then you have the Gacaca domestic process. In any mass atrocity situation, we need multiple levels of trials. And sometimes, therefore, I think we get a little sidetracked in the debate. Which mechanism, what is the best? We actually have very little established. We need to work on all of the above, and we will need multiple mechanisms because the crimes are that numerous. And in addition, and at the national level, of course, work with Syrian and Iraqi courts eventually in their capacity building. I also want to point out that our contemporaneous tribunal with the greatest capacity is the Yugoslav tribunal. And they issued 161 indictments. So some of our hybrids have done things, pardon?
After 15 years.
Yeah.
Yes, but international justice is sometimes a slow endeavor. They obtained all their indictees. Now, some of our hybrids have achieved nothing near that. So the ECCC is doing a handful of cases, Sierra Leone Special Court. did 9 cases. So I think this is an important model to consider. It's very unpopular to talk about the ad hoc tribunals because they were very expensive. But if you want serious capacity, they are our model. Finally, I think we need to project that accountability is coming. Here I'm very disappointed with the prosecutor's statement on April 8. She said the jurisdictional basis of opening a preliminary examination into the situation of foreign fighters as part of ISIS is too narrow at this stage. She's not moving on it. And that's unfortunately the opposite of what I wish she had said. At least she could have said, we're continuing to monitor. We have to see which foreign country nationals are implicated in what crimes. At least she could have said the ICC is looking and monitoring and actively monitoring the situation because the court actually has a fair amount of jurisdiction. Eighth, justice must not be bargained away at the negotiating table. If there are ever resumed peace talks, as were attempted in Montreux, Switzerland, ideally you'd have a commitment to justice. Secondarily, you just want to ensure that the peace process doesn't foreclose the possibility of justice. And finally, I would like to end with just the idea we need a little bit of optimism to stay the course and aim high for the best possible justice outcome. And here I was reflecting on the improbability of creating any of the justice mechanisms we've had. So I think when the UN Security Council first created the Yugoslav Tribunal, they didn't actually know this would work. It was just a statute attached to a resolution. And then for years, they didn't know how would they get Karadzic and Mladic to The Hague. And these had to be campaigns and sustained pressure to achieve this. Heading to the Rome negotiations, there were so many brackets in the text, there could have easily not been an international criminal court statute, and yet there was. So when David Crane, first prosecutor of the Sierra Leone Special Court, indicted Charles Taylor, did he have confidence he would be apprehended? I mean, this is a tall task. At that point, he was still a current head of state. Yet through sustained pressure and international commitment, he was apprehended and tried. So I think the report is a little bit pessimistic. It has some reasons why none of our processes or may be difficult, and certainly they will be difficult. But I think one has to have lofty goals and a sense of optimism, because it wasn't particularly easy creating any of the tribunals that we've had. So in conclusion, while prosecution is always second best to preventing atrocity crimes, the field of international justice has come too far for horrific atrocity crimes such as those being perpetrated in Syria and Iraq not to warrant a robust response from the international community. Every state owes a responsibility to ensure that this happens. Thank you.
Well, I thank all 3 panelists, and I know that there's a little tension between some of their recommendations, which I think will make for a good follow-up discussion, both by the panelists and ultimately by the audience. So let me just sort of start it off with 2 questions directed to different people. The first question could go to both Mohammed and Swadamore, and that would be, when you've heard Jennifer's case made for taking perhaps a more assertive or perhaps a more optimistic notion toward what we can do now. Are you convinced? I mean, you suggested, or at least I think you suggested that maybe it's better to wait, not to do something bad that's going to prejudice future efforts. She's made somewhat of a case for, if you see an opening, go in there and go for it to some degree. I'd be interested in your reactions on Mr. Laver's, and I have a different follow-up question for you.
Thank you very much, Judge. Definitely, I'd be happy to see something starting, a jurisdiction happening. But the story in the eyes and minds of Syrians is totally different from the story, the mind and eyes of a professor or academic or even practitioner or former prosecutor. The head of the opposition coalition was in DC recently. He met with Secretary of State Kerry, and then they did a town hall meeting for the Syrian in DC. I attended and I asked a question about the kidnapped famous human rights lawyer Razan Zaytouna, where she is, and if we can file a lawsuit against the militia who's kidnapping here. And one of the audience who's here today asked me why you don't file a lawsuit against Bashar al-Assad. Why you want to target the militia? Because, of course, there's limitation in the jurisdiction. But go back to Syria, ask 10 million or 9 million displaced and refugees and tell them, here's what we have, and this is better than nothing. They will tell you immediately, you're sided, you're targeting one side, you're staying with Assad or siding with Assad, you're investing in Assad under the table. And here's the problem. A, there's no deterrence factor will happen in Syria. After using chemical sarin gas against people and go without punishment of that, the entire deterrence factor and concept a little bit is difficult to sell to Syrians. That's one problem. And the second thing is there's the fighters underground setting up their justice system in court justice, Sharia courts in every place, and they're running all over the liberated areas. And unless you bring them alternative that's acceptable and convincing to them, they will not accept it. They will continue with their Sharia courts, which is not courts by no mean, like by any mean, it's justice problem. And here why SJAC try constantly to work on the overarching transitional justice approach, because no matter how good your justice system will be and accountability mechanism, you won't be able to satisfy everybody, but you have alternatives. Truth-telling mechanism can fill some of the gap. Preparation programs to some of the victims can play a role. Memorialization events can play a role. And vetting and restoration and getting some of the bad actors out of the system will be another part of justice. It's not all criminal prosecution. One comment on the negotiation table. Unfortunately, Stefan de Mistura, the UN envoy, did not even have justice at all in the table. It's not in the negotiation, the bargaining. We don't care about justice. Let's solve this, and how he's going to solve it, I don't know. But he was backed by everybody, including the UN. And we have not really seen any strong statement from any of the state parties saying we need to hold the perpetrators accountable, so we move forward. That's why when Syrians become very pessimistic and they lose their trust and confidence in the system, okay, there's a reason for this, not because I hate the justice mechanisms. And honestly, I would quote our board member, Yu Chang from Cambodia, from the DC camp, who appeared in New York Times article 2 days after the verdict in last August in Cambodia. He said, from the beginning, we knew the court will not solve anything. Because two defendants were 88 and 82 years old. And if you tell Syrians Assad will be in The Hague for the next 15 or 20 years, I have like 20 Syrians here, like they can comment on this. And precisely that's bringing the death penalty issue. I'm not advocate for the death penalty myself, but if you don't have death penalty, you will lose Syrians, but if you have death penalty, we'll use UN fund and European fund and so forth. And here finding a common ground between this, it's a difficult issue, and basically making the case for people. And I usually face by this question every time I meet Syrians, like, oh, after all this killing, almost 250,000 human beings get killed in brutal ways, torture cases is really severe. And then we're going to send Bashar al-Assad to 10 years, 5-star hotel in The Hague, in prison. And that's why when Mubarak trial happened, we wrote a very strong blog post saying, all these bad examples of domestic justice in the region bringing really negative impact on Syria and the neighboring countries, because the message from Syrians after Mubarak trial and he was released not guilty was, okay, the best model is Gaddafi style, kill him in the spot, otherwise they'll lie to us, take him out of the country and he will be granted asylum somewhere, or he will escape justice. I'm not pessimistic, but honestly, I feel sorry for the person who will be in charge of this case in my country, because I think they will be under lots of pressure.
Do you want to add something to that?
Well, I just wanted to say how tremendous I thought Jennifer's remarks were, because I think she managed to distill in a relatively short space of time an enormous amount of very good practical points from other tribunals, other justice systems around the world. And there were very, very few things on which I disagreed. But I would say, just to come back to the report, that I think both Mohammed and I agree that you have to be a little bit careful about sort of totally half-baked or cat-handed ideas that sometimes circulate about how you deliver justice to Syria at the moment. And there would be nothing more damaging than establishing some kind of tribunal which was obviously one-sided, which obviously only looked at which was heavily dominated by certain interests or certain states which were coming from one side of the conflict. I mean, I don't think any, and not only would that be damaging, but I think it would also totally finish any prospect of there being a better international tribunal after the end of the conflict. But to come back to the recommendations of the report, we do believe that it's important to start now. And you know, no one's working harder than Mohammed and his colleagues on trying to establish the groundwork for justice. But I think we have to also start operationalising that. And for example, by doing a series of prosecutions in foreign national courts, we could achieve quite a lot. But crucially, they can't just be about these foreign fighters. It has to target, they have to target perpetrators from across the spectrum in Syria.
Can I just follow up with that, and then I'll get to Jennifer's question. If you think it's so important to target the most serious offenders, and we certainly have this running through all back, and that's what actually was in the charter of the Sierra Leone, and we had it, although for many years actually, we could, on the Yugoslav tribunal, it was 10 to 15 years before we were able to get, I mean, I was leaving the tribunal just as Milosevic finally was handed over to them, and that was much later that they got Karadzic and Mladic. So, you know, it's, I guess, I'm somewhat concerned, it leads me into my question for Jennifer. When you talk about having many levels, and I agree, I mean, that's fine. But here's my basic question. Even the Yugoslav and Mladic tribunal, which you cite very favorably, not everybody does, but you do, but they really didn't get operational until the fighting was over, until the conflict was over. I mean, the ICTY was established in 1994, 93 and one in 1994, but the Dayton Accords came in 1995. They didn't get their first defendant. Then they only got it by Germany handing over somebody Germany already had, who was not a foreign fighter, but a low-level guy, just a hanger-on who went into the prison camps and tortured people because he, with no official kind of responsibility, was only, in fact, Goldstone, who was the first prosecutor, was criticized very often for not for bringing cases or allowing cases to be brought against the lower level. So I'm not sure I agree with you. That's the ideal system to have all of those levels. I'm wondering if your experience suggests that when the ICC, for instance, has brought some indictments against people from ongoing conflicts like the DRC and Congo, do you have any lessons that you would draw from those as to whether they've had, they've had some difficulties? Maybe they justified bringing them in the first place, but I'm just wondering if you think there are lessons to be learned from those cases where the conflict is still ongoing.
Yeah. Thank you, Judge Wald. Yeah, it certainly makes prosecutions much more difficult. And I guess fundamentally, I have to say I'm not that much in disagreement with the report because I think there's certain steps one can take now and they should be taken. But ultimately, a real tribunal on the scale of ICTY or ICTR would have to wait much later. And I was only citing the ICTY favorably, and the ICTR is its corollary tribunal that has functioned as a one-sided tribunal. So a less successful...
Actually, I've interrupted you. Just on the ICTY, when I was there, which was way back after they'd been in operation for 6 or 7 years, we didn't have any Soviet.
It was very disproportionate, right?
It was many years later, as they were just indicting their first Bosnian Muslim.
Right, I think Bosnia chose to cooperate first, and then you have Serbian cooperation much later under EU and US pressure.
It went under 6 years, in which we were criticized by the European justice for just that.
Well, tribunals take a while to get going. I mean, they're also really, the ICTY and ICTR had to create their process. Our prior tribunals were Nuremberg and the Tokyo Tribunal. So if we say, wow, it really took a long time for them to get going in their mandates, they didn't have a lot of precedent at that time. So I guess I am saying, not so different from the report, one does what one can now. It's the only possibility of creating deterrence. Ultimately, you want a full-fledged mechanism, and that, I agree, probably has to be later. I don't quite see how it's going to be created under current conditions. And I certainly wouldn't back a one-sided hybrid kind of mechanism. I do think we will need levels of justice. It's just a capacity issue. So if you look at the ICC in each of its situation countries, it only issues a handful of indictments. And I think this presents tremendous capacity challenges because the theory is that national courts are going to take over. But the ICC is working in cases where, well, at least it has the cases because domestic courts were unwilling or unable to take the cases it is taking. So these are not situations where there is any kind of robust domestic capacity. So I think the ICC model has some challenges in it. And I do say that in terms of dealing with the numbers, ICTY, ICTR, with 3 tiers of justice, and I don't mean to exclude Mohammed's suggestion of vetting, lustration, security sector reform, truth commissions, the full transitional justice panoply, ideally as well. So I do think there are our best model, and it's certainly, you know, trying to do prosecutions when conflict is ongoing. You may not get in your situation country, and that's a classic difficulty. Although for Syria, we have a lot of people out of country, you know, at the moment. But it is very difficult to prosecute in the midst of ongoing conflict. And it also, you know, presents potentially additional challenges in terms of witness protection. So it is complicated, and I do ultimately agree for a full-fledged response, we'll probably have to wait for a later date.
Okay, I have one other question, and then I may throw it open after I ask the panelists if they would like to respond to each other. And that is, if you decide that maybe you could do some good, one step at a time, through domestic court prosecutions, are you necessarily limiting yourself now to sort of courts in the Western democracies? The reason I raise this question is that your reference to the ICC and their whole complementarity, well, what I know about that, or the reports that I've read about that, it's largely been stymied in many cases by the fact that so many countries in the world do not have a tradition of independent judiciaries, and they don't have a tradition of well-resourced prosecutors, up-to-date technology, etc. And you want it, as you point out, you want the results to be decent and have some credibility. So realistically, are we just talking about a handful of European countries that could possibly leave one standing? I'm sorry to ask tough questions.
No, it's the reality, and that's why, I mean, the problem with the prosecution in Europe now, as Mark mentioned, it's one-sided. And as Jennifer put clearly, there's more problems. I mean, there's tons of Syrians, 3 million Syrians refugees between Turkey, Jordan, Lebanon, and those. Eventually, we have witnesses, victims, could be accessible for some cases. For example, in UK, a British citizen was tortured to death, the physician assassin. And there's no case, there's investigation, but none of the Syrians defectors who were in part of the regime or the police or the intelligence were asked to testify in UK or in London, or to provide analysis how the torture mechanism starts and who run the detention facilities, etc. Because there's witness protection problem, and there's no deal with the prosecutor. You can't do like the US, because majority of those people who defected have committed crimes at some point before they defected from the regime. So what I would say, I would encourage that the European governments, and yes, indeed the Western democracies, who would be able to access perpetrators, arrest those, to encourage them to increase the number of those cases, to include non-jihadis and non-foreign fighters only, to open it up a little bit, to accept more cases that might include some former regime officials. Go ahead.
But if you go down that route, does it run the danger that you yourself talked about earlier, that if the people in Syria look and they see that these prosecutions are happening in countries, you know, far away, remote, cultures are different, backgrounds different, its language is different, does that decrease the credibility?
It will bring a fire back indeed when Sweden prosecuted the former fighter from the Syrian army. The reaction was really bad from Syrians. Why you targeted one side, you ignore the others, you're not working with Syrians, etc. And the point I'm trying to make is to communicate this more to Syrians that that's what's accessible now, and those are the people we can get hold of and we can prosecute. And second, to not prosecute from one side, to open this up a little bit. There's a high level of cooperation, and Mark elaborated on this yesterday in the UN briefing, high level of cooperation between migration and law enforcement authorities across the European Union.
Are the kind of defendants that you want realistically accessible?
No, that's another problem.
Would they have to be abstention trials?
That's another problem. The people who's accessing Europe and exist in Europe today are not the regime people, are not people from the high level in the government. But a point might come when those people start leaving the country, and then we'll be able to target them.
Okay. What I'd like to do now is just for 1 minute, and then I'll throw it up to the audience. Give each of you just a chance to ask a fellow panelist or to either ask a question or make a 1 minute comment on something that you wanted a chance to respond to that one of the other panelists had said, and then I think we'll throw it up to the audience question. In other words, to something anybody here on the panel said you wanted me to respond to that you didn't have a chance to,
I think
or you
I'm
want to
good.
ask them another question.
We're fine.
We're fine. Yeah.
All right. Then do I have somebody, one of the ABA staffers is going
Yeah, our colleagues are.
to go around with yes, okay, show right there.
Hi, how are you? Thank you for having us here. I'm Diyar Wesley. I'm a Syrian lawyer. I have worked with the Rule of Law Initiative before, American Bar Association. So my question for Mark or like comment, I have heard many things about the international level or like ICC, other potential to prosecute the criminals on Syria. I wish I would have heard something regarding to the domestic law, because Syrian law is designed in 1950, so this is something like I have to highlight. And in the first 20 articles in the civil law itself, Syrian law adopted the international principle and the international law. So we can just rely on this article to do some in the prosecuting now for this level. If you would to work more or to start early this tribunal, it's not conflict of laws, which law that the tribunal would do. It's a term of mechanism, as Muhammad mentioned. It's how would bring those guys to the tribunal. How would we don't have law enforcement now in Syria. So my question, is there any potential, and especially in the southern area in Syria, like Dara, and this is for you and Muhammad, I want Muhammad to highlight this, to start working on the domestic law with the guys in the southern area, especially we don't have ISIS, we don't have Al-Jabha from there, and we can rely on the civilian law itself, which is adopted the international law. Thank you.
We have time and
Okay,
we'll answer
yeah.
one by one. At the end, there are too many, I may have to group them, but let's.
Sure. I don't think the problem is the law itself. It's you want to prosecute people for crimes against humanity and war crimes. We don't have judges experts with this. We do not have prosecutors experts with this, and we do not have adequate security measures. And of course, if you want to prosecute a limited number of people, you have to tell the entire society why. Otherwise, all the society will be enemy of the tribunal. Libyans had gone really further in this. There are tons of people, I think 8 to 10,000 people, and from Gaddafi's son to the foot soldiers. But then they have a problem with feeding them, securing them. They open secret prisons and torture is back, which is not a thing we really want to see in Syria. It's not conflict of law, but more it's honestly we lack the capacity. And here where I want to highlight something Jennifer said about the hybrid mechanism, because the hybrid tribunal would employ lots of Syrians in it, and there's a potential capacity building and learning when you bring international experts to put them together with Syrians to work in this. The second point on Dar'a local justice, honestly I'm very discouraging of this model. I'm against it fully because we might run the problem of having multiple justice sectors that overlap or work against each other. So if a couple of months later the north will be fully liberated and you have another justice sector there and has different judgments against the ones in the south will say X is war criminal and the north people will say no. There's a problem. And I think if I understood this correctly from different European and US colleagues, they're not supporting justice sectors in the liberated areas because there's a fear and concern of running a parallel justice sector that will be very harmful in the long run for Syria.
Okay, thank you. Go ahead, Tim.
Thank you. I just wanted to ask about the assertions about impact, and throughout the report you go through the impacts of each option, but the impacts are always limited to the impact on Syria. Mm-hmm. As we know from every single one of these previous tribunals, the impacts go well beyond, and they set precedent that then informs how these tribunals are used, either for the normative advance of international crimes cases prosecution, or as geopolitical instruments. So I just wonder to what extent you considered these impacts in terms of each option, even just within the region. How might this create a precedent where someone might say, okay, we're going to use this in Iraq, we're going to use this in Egypt, we have the accusations of torture now in Sinai and everything. And then of course beyond. You look at the Russians in Ukraine, and they'd say, well, we also need humanitarian access, to get in and assist the humanitarian situation in eastern Ukraine. Might they then say, well, we also need to establish, a tribunal, extraterritorially, maybe we'll have it in Moscow, and maybe we'll prosecute the horrible crimes going on in Ukraine. My other question goes to perhaps what one might consider an overly optimistic perception of some of these tribunals. And I'll go firstly to the characterization of Special Court for Sierra Leone. They tried all three parties to the conflict. I mean, anyone that looked, sort of superficially even at that conflict knows there's more than three parties to that conflict. Guinea attacked Sierra Leone. There were United Nations and West African peacekeepers in Sierra Leone that committed mass atrocity. In fact, the statute of the Special Court for Sierra Leone excludes them from jurisdiction, gives them impunity for the crimes that they committed, as well as crimes committed either by British soldiers or persons under the control of British soldiers, anyone that acted under agreement with the Kabar government. So, but even if you put that to one side, if the litmus test is to prosecute personnel from each side, and this is where perhaps I orient more to the comments of the judge, that also should that be the litmus test, instead of to what extent does the justice that is meted out reflect either global, regional, or local power asymmetries.
Okay, those are two tough questions. One tough question with two subparts. Anybody want to volunteer on this?
I think the second question was to Jennifer.
Well, I guess
Yeah.
Sierra Leone was aimed at me, but I guess I will agree with your comment on impact. I do think it's broader than just regional. Sierra Leone, the court had very limited funding, limited mandate to prosecute those most responsible, and it was only able to do so much. It did prosecute the 3 main warring factions. A lot was left undone. Unfortunately, there was a domestic amnesty. The courts have not picked up the slack. Now there's a huge impunity gap. So Sierra Leone is a model, but the totality is not. And there were many crimes left. And it's what I fear in our ICC situation countries when we're relying on domestic courts to do all of the remainder. This often doesn't happen. No, I'm sure none of our institutions are probably perfect institutions. With more resources and more funding, I'm sure the special court could have done more. It did what it could in the time and mandate it was given, and then left the rest to be done, and it ultimately wasn't. I think there were a very limited number of prosecutions that were not covered by Lomé, and post-Lomé crimes could still be prosecuted, but the remainder were not. So it's not an entirely satisfactory model. Yeah?
Yeah, I'll just say, the jurisprudence of the court said that crimes before Lomé could also be prosecuted. So the Lomé amnesty was struck down by the jurisprudence.
But they never did. They never did it domestically.
It's too far. It's really here. You go ahead and say that, but before I just wanted to lay out the protocol. I think given time after Mohammed finishes his comments on this, we'll take just a couple more questions together on all parcel.
So quickly, the impacts on neighboring countries, definitely that exists, of course. But what we try to do here is try to bring Syrian perceptions to the table, because honestly, there's the ones who are overlooked and overheard, like people ignore them. When our colleagues presented the Chautauqua blueprint here in Washington, they had no Syrians and they had no Arabic translation for the proposed statutes for Syria. That was quite insulting to everybody, quite honestly. I mean, I cannot even talk about their qualification and expertise. They're all expert in the field. Professor Sharif Bassiouni is one best friend of them. But I think definitely Syrians need to be consulted in this, and that's why we're bringing this perception. When ISIS executed or burned the Jordanian pilot alive, the Jordanian government did something. They basically executed 2 former Qaeda prisoners. They were sentenced to death, but they were kept in prison for 9 years. But we wrote an article on this, warning of the harmful behavior of using justice sector for revenge mechanisms. Because if you use it once, you get the question why we cannot do it now again, why we cannot use our justice sector in neighboring countries to execute our enemies the 3rd time and 4th time and so far. Definitely there's lots of impact between these countries. They impact each other, and we cannot treat Syria as a isolated case, because what's happening in Egypt, of course, has lots of consequences. Mubarak will be compensated for his 4th year in prison. He didn't deserve. Gaddafi's son is not being delivered to the ICC. Ali Saleh in Yemen granted impunity in the Gulf Clinton initiative of negotiation. So all these countries impact each other, but honestly the most we're concerned about is how it's impacting Syria in the long run.
Okay, are there 2 more questions? Okay, there's 1, 2, and that's, why don't you?
I'll be quick. This is a question for Mohammed or anyone else who's interested in taking it, but do you think there's a tension between what justice efforts will work in the long term and what's popular with Syrians today? And if so, what do you do about it?
Thank you, all the panelists. Particularly for Ms. Strahan, I think coming from the perspective of the situation and accountability, is there a mechanism to hold states who have been indirectly involved accountable?
Okay, that's 2. We'll take 1 more and then we'll parcel out.
Yes, I guess this is mainly for Mohammed. On the question of foreign prosecutions of Syrian officials who are responsible for crimes, I mean, it is at least theoretically possible that a foreign country could indict a Syrian official for a crime that was committed, for example, against someone who had its citizenship. Let's take Argentina has a Syrian diaspora. It's possible victims in Syria have had Argentine citizenship, and Argentina has a command responsibility theory under its law. And so theoretically, Argentina could indict a Syrian official who, say, ran a center where an Argentine citizen was tortured to death. And that would then potentially activate a lot of different mechanisms, an international arrest warrant, which would cut down the possibilities for travel, freezing of economic assets, things like that. And so, I think that there are possibilities there. I'm wondering what you and others who are trying to document the crimes in Syria are doing to gather the kind of evidence that countries could use. What is the citizenship of the victims? Who's in the command responsibility positions there? Who's running these centers? Who's commanding the squadrons that are carrying out bombardments of civilian areas?
Okay, great. I've got 3 questions. Mohammed, I think one was especially directed toward the long range, short range.
Yeah, tension between what Syrians want and what's available. Yes, there's tension. Syrians are suffering and they hurt and nobody helped them and they feel betrayed and nobody stepped to the occasion and tried to stop what's happening, and that's why they over-demanding things, and that's why we try to control or manage the expectation a little bit by communicating to people this what's possible and feasible, and to be realistic. If you want a death penalty, you might get it, but you will lose Europeans and the EU, for example, and try to make these trade-offs very clear, where if you want to select one path over other, you will pay some price and back. So there's a problem here, and this is one of our missions to work to communicate more in easier language to the Syrian communities here, and more importantly in Syria, that why this is positive and why this is negative, and why this should be representing the best interests of Syrians, not other countries who's intervening in the process. On the documentation, yes, there's lots of documentation efforts and could contribute potentially to some of this prosecution. That's why we're encouraging to open and widen the spectrum of the target base of those individuals, not only jihadi fighters or foreign fighters, but also other Syrian regime officials. We've been in touch with several prosecution mechanisms in Europe, I would say, at this level, leave it at this level, but we're open to use this documentation against any human rights perpetrator in the foreign national prosecution jurisdiction or other jurisdictions. The practicality here, and what Judge Wald noted, is the trials in absentia, because the vast majority of Syrians out of Syria today are non-regime affiliated people. The people who fleeing the country are either the opposition or the civilians who live. But at some point, this dynamic might change. You might see more Syrian officials getting involved and leaving or flying around, and that's a point where we can target them. And I'm not sure if Mark want to touch base a little bit about our project.
On either of those first or third questions, long range, short range, or on documentary, is the last question.
Well, I think you raise a very important point about victims who may be citizens or nationals of other countries. I mean, that's covered in our report. It's sometimes referred to as passive personality jurisdiction in criminal law terms, but it's certainly one of the bases of jurisdiction on which European states, for example, may wish to advance prosecutions of Syrian perpetrators. I think, in Pinochet we saw a mixture of this. Some of the victims that he was accused of having been responsible for their deaths or their torture were the nationals of some of the states who were seeking to extradite him, but not always. So I think that's one of the important factors. In terms of perceptions and overall impacts, there is just one thing that I'd like to say, which is that, if you're looking at a justice mechanism for Syria which has to be able to deliver stability to Syria, then it's going to fail. I mean, there's a danger in loading onto a justice mechanism this kind of expectation to somehow create a perfect society, I mean, and sometimes when you hear people talk about it, it's almost like they're seeking to do. I mean, even deterrence is not exactly an argument which has been firmly won. You know, to do international criminal justice mechanisms really deter perpetrators? Well, I mean, I believe for certain reasons that in certain circumstances they might, but it's certainly not a clear picture. And I think you've got to say to yourself, what is the best argument for justice? And the best argument for justice is not actually conflict prevention. It's not stability. It's actually justice. It's because victims who have suffered in this way deserve, it is their right to see justice done. And that's really why I think it's important that we have to start with some of these cases to try and move towards a process of seeing some justice.
Jennifer will say the last one for you, which would be, is there some justice mechanism that can hold a state responsible? So,
Yeah, thanks. But first, let me just say, I think Mark is absolutely right. One has to have realistic expectations of these mechanisms. They'll primarily deliver justice. They can contribute to peace, but it's kind of an indirect contribution. I think it's often simply marginalizing bad actors if they're under indictment. It forced Karadzic and Mladic to go underground to get off the political stage. It's rather an indirect contribution to peace. They maybe create some truth, but it's not a historical narrative. Maybe they set the foundation for reconciliation. They don't necessarily achieve reconciliation, so we have to have realistic expectations to begin with. In terms of indirect responsibility, at the international level, one might analyze it. Is your person who is assisting, aiding and abetting the crimes, are they complicit in a joint criminal enterprise? In the U.S., we tend to use conspiracy instead of JCE. And you look at the individual's contribution and their mental state. So that would be the test for any individual who is directing operations, unless they're very directly involved. Maybe they're ordering, maybe they're participating. So those are kind of your verbs for an individual who may be involved in crimes in Syria. In terms of state responsibility, I think that's a potential ICJ case. And it would be kind of like, you know, when Bosnia sued Serbia, an issue for Srebrenica, and the ICJ said, well, you owe a responsibility to help prevent, you failed, but no damages. I don't know how they how they come out to, oh, but no damages for failing to prevent genocide. But anyway, a disappointing verdict, but it illustrates, so there is a state responsibility level in addition to the international criminal responsibility. So two levels potentially to get outside actors who are implicit in crimes.
They sometimes operate together. The Bosnia-Serbia case was brought 10 years before the ICJ, 10 years before it finally got decided. In the meantime, we have the individual cases at the ICTY. I sat on the trial of the Srebrenica. We made all the fact findings about which general did this and which general did that, and where did they get the help, you know, from Serbia for the Bosnian Muslim general. The ICJ, which has at that time, had no fact-finding capacity. We actually heard witnesses acted like a regular trial, but they did not have that capacity. What they did was reach down and adapt and accept our findings from our court, the appellate court, which upheld most of them, and incorporate them into their findings, ending up with findings that they had contributed toward genocide. But actually behind the scenes, Serbia was very, I am told by my friends who stayed longer than I did, and they said that there was a lot of distress on the part of Serbia's side. They were very, very upset with the thought that they might be found guilty of genocide, as they stated. So it really did have just the notion that you might, even though obviously they couldn't get an injunction against them or bring the state, put the state in prison, etc. It did have some effect upon them. They felt very apprehensive in trying to, build their relations and get into various international organizations. They did not want that finding. So the ICJ is slow, glacier-like, but, it can. But it does work in conjunction with the individuals. So sometimes the factual basis is laid. Basically, it's the same. With that, I think we will conclude our panel. I hope you'll join me in thanking the panel and the report.